I just want to mention something. First of all, you will see here, after my name, some letters, which basically means I have a degree in law. It does not mean that I am a lawyer, because I'm not a practicing lawyer. I don't have a practice certificate. I'm not in legal practice. So I just wanted to clarify that, in case anybody thinks I can give them a state aid advice letter, which you'll require for your project. Unfortunately, I can't. Used to under the old programmes, because they didn't always insist on independent legal advice. Quite a few of them went through just on my recommendation. I'm always a bit nervous about that, but nowadays they insist on independent advice from a proper solicitor, i.e. not me. So that's just to clarify that point, if I may. You will need independent advice. So we're going to just spend half an hour or so just on this. So I'm going to start off hopefully in a logical order. I want to explain to you first of all the notion of aid, the notion of state aid I should say. Notion meaning concept, the concept of state aid. Just in case anybody doesn't know what state aid is. If you don't know what state aid is, you're in good company, because arguably some academics argue there isn't a proper definition. But anyway, we'll come on to that. More importantly, we'll look at the state aid criteria. So how do you assess what is and what isn't a state aid? Looking at the different criterion tests that are applied. Then we're going to look at the general rule, fairly obviously, is that state aid is de facto illegal within the confines of the internal market, which we're about to leave, but we'll probably still have those rules anyway, I suspect. But of course, to any rule there are exceptions, and that's what we're really interested in here, aren't we? Because yes, of course, the money coming from structural funds is public aid, potentially state aid. How can we ensure that aid is compatible with the rules of the internal market? That's what I'm going to talk about. So there are exceptions. So we have a number of possibilities. We can use existing state aid schemes, i.e. schemes that have already been notified by the UK government, that have been approved by the Commission. Obvious example is broadband, isn't it? I know you've got major broadband infrastructure projects. I saw it on the news last night, actually. Some more broadband infrastructure. And there was an ERDF logo in the news bulletin. I was really pleased to see that. They followed the publicity rules. And broadband is already part of a notified state aid scheme with the Commission. At least I hope it is, it should be. So therefore it's been cleared through a state aid scheme. There is also broadband exemptions, but it's a proper scheme. There's something called the General Block Exemption Regulation, the GBER. People in the business will just use the term GBER, the GBER. This is the one that you are most encouraged to use, if at all possible. The Commission are trying to get 90% of state aid to be approved through the GBER scheme. So, and you will find the managing authority will say, have you looked at the GBER? Are you sure this doesn't fit under the GBER? Because they are being encouraged by the Commission to fit their aid schemes, including ERDF and ESIF, under the GBER where possible, if indeed there is aid. However, if that fails, there is also the fallback position of what's called de minimis aid, which can be incredibly useful. Well, still a lot of ERDF projects are supported under de minimis. De minimis aid means aid that is below the level which will distort competition between member states. It's too small to be bothered with, basically. So you can potentially, at the level of the end beneficiary, let's say it's a business getting business support, you can potentially fund that under de minimis because it's not going to distort competition between member states because the aid level is too small to worry about that. I'm just going to mention state aid and infrastructure, horribly complicated subject. I'm going to finish with notification, just for the purposes of completeness, but you really aren't going to want to do that, and I will give you a story as to why you're not going to want to do that when we get there, because it is something of a nightmare process, to say the least. So what is state aid, first of all? Let me just read this bit out to you, it's not on the slide. An advantage in any form whatsoever conferred on a selective basis to undertakings by national public authorities. National/public authorities, I should say. That is what a state aid definition is. Where does that come from? That comes from the Commission's website, DG Competition, who are responsible for state aid policy in the EU. I've simply read that out. But let's have a look at the criteria, which says pretty much the same thing. So the first question is the aid granted by a member state or through state resources? You might say, hang on, we're talking about EU funding here. And this is quite an important definition here, because who makes the decisions on whether projects are approved or not in the structural investment funds? The managing authorities. They are part of the state. So even though the money is of EU origin, arguably, I know we pay money in and then get money out, but setting aside that argument, it's of EU origin. It is, and the Commission have confirmed that ERDF and ESF is treated as public aid through member states. Somebody said to me the other day, why is Horizon 2020 money not state aid? Well, the answer is in the question, isn't it? Because who distributes Horizon 2020 money? The Commission. The Commission is not a state. Therefore, Horizon 2020 money cannot be, by definition, state aid. However, if you've got other public funding in a Horizon 2020 project, then of course that can be covered by state aid rules. So there often is state aid in Horizon 2020, just in case you think I'm giving you carte blanche to ignore it. That's not the case. Does it provide an advantage? Does it favour an undertaking? So first of all, does it distort the market? Does it distort competition in any way? And there's this really interesting term here, undertaking, isn't there? What is an undertaking? Now, an undertaking is an organisation involved in economic activity, effectively. So some people say to me, oh, the university is not an undertaking. Well, that's generally true for most of its activity. So the provision of education, provision of the actual delivery of research is primarily non-economic in nature, which means that most of what universities do and some research institutions is not state aid. I'll come back to that later on in a bit more detail if I may, but however, that does not mean that the organisation is not capable of entering into economic activity, and a lot of projects will be doing exactly that. So I've seen some dreadful, oh God, this is being recorded, isn't it? I should be careful what I say on this one. I've seen legal advice where a local authority was described as it can't be state aid because the local authority activity is, is not an undertaking because it's not involved in delivering economic activity. Rubbish, that's rubbish. If it is involved in any economic activity, it can be treated as an undertaking. It is the nature of the activity, not the nature of the organisation that matters. Really, really important in state aid law. So yes, the university, for most of its activities, is not state aid, but can be, for an ERDF project, it can be state aid. So you have to be really careful with that. It's not a way of getting around it, I'm afraid. Is it selective? Is it favouring certain undertakings or certain goods? I suppose the best way to explain selective is to explain what is not selective. So a non-selective government action would be setting tax rates. So corporation tax is what, 20%, isn't it? 20%. If the government says we're going to change corporation tax to 19%, that is not a selective measure, it is a general measure. ERDF and ESF is selective in nature because, and again I've seen legal advice saying that the giving of a grant through an ERDF programme is not a selective activity. Well, it is selective, I'm sorry, it's selective. It is a selective activity, it's selecting one organisation over another. Not all organisations are going to get the same ERDF grant, are they? It cannot be a general measure. It is selective by nature. You might, just as an aside, I'm sure you've heard of the Commission are really clamping down on tax, corporation tax and company tax issues. I'm sure you've heard of the big case in Ireland, Apple in Ireland, where the corporation tax in Ireland is lower anyway than most member states. I think it was 15-16% or something. Apple paid about 5% tax to the Irish government. The Commission said, because they did a special deal with them, the Commission said this is selective. It's not a general taxation measure. This is a selective activity. It's de facto illegal under state aid rules. And as you know, that one's heading for a very big court case at the Court of Justice of the EU. That will be fascinating to see that one go through. I don't know how on earth the Irish government think they're going to argue otherwise, but anyway, very interesting example of selectivity. And finally, affects trade between member states. A lot of people will say, well, our little project in Cornwall hardly likely to affect trade between member states. Well, actually, the threshold is very, very low. Almost anything these days can be deemed to affect trade between member states. When you think about it, things go on the web, don't they? You know, it's easy to access from anywhere. It can be, it's not usually, some people think, well, that's the easy one. Well, because all of these have to apply, by the way, for it to be a state aid. They are cumulative. It says that, doesn't it? Have to be fulfilled simultaneously. So all four have to be fulfilled simultaneously. All 4 or 5, 6, depending on how you count them, have to be fulfilled simultaneously for it to be an aid. So general rule, all aid to be notified and approved. But there are exceptions. There are approved aid schemes. There's the block exemption I'm going to come on to in a minute. If something fits under the block exemption, it is treated as being compatible aid. Doesn't mean it's not state aid. It means it's aid that is compatible with the aims of the single market, or what should be called the internal market. Or there's de minimis aid. Anything that doesn't fit under there is de facto illegal. And I perhaps make the point here, and this is one of the reasons why you have to get state aid advice. It's always the recipient of the aid that has to repay the aid. Doesn't matter whose fault it was. Andy told us this project was state aid compliant. No, you're telling us it isn't. It's Andy's fault. Doesn't matter. You've still got to repay the aid. And the reason for that is that it corrects the distortion of the market under EU competition law. So therefore, if the market has been distorted by the aid must be repaid, therefore, to sort out the distortion in the market. You follow me? So it doesn't matter whose fault it is. And that's why you as a beneficiary need to get your own independent state aid advice. You are liable to repay the aid if the aid is illegal. It doesn't matter if DCLG told you the aid was fine, gave you a grant funding agreement, and then someone turned up later on and said, actually, this is illegal aid. It doesn't matter. You can't blame DCLG. You're still going to have to pay the aid back. Witness a very good case if you want to look one up. Ryanair. I love Ryanair. Fantastic flying. They got a huge subsidy for flying for Brussels South Airport, Charleroi. There was a state aid complaint. The Commission investigated and they told Ryanair they've got to repay all the aid they'd had. Ryanair incredibly unhappy, said it's not our fault. We were given a subsidy by the airport. Why should we have to pay it back? Tough. You've got to pay it back. And they went to court and they had to pay it back. That's how it works. If you want to look up the definitions of those tests I just went through, there is a really useful document called The Notion of Aid. I've given a little link on here. Commission notice on the notion of state aid, as referred to in Article 107, which is the article in the treaty, TFEU, which refers to state aid. So this will it's quite a long document, but it's really useful for lawyers actually. It gives, under each of those tests, it gives the current case law. And you can see where cases have been brought. The Commission have set out the current case law in a really useful document. And this was published only in 2016, so it's a really, really useful document, not just for academics and lawyers, but also as a reference document as to what is and what isn't the state aid. So you'll see all kinds of interesting cases under that, as to where people have tested the concept of selectivity, advantage, undertaking, whatever it is, being tested, distortion of competition between EU member states. You'll see the cases that are a current case law that define what this actually means. I just want to mention here at this stage as well, in case I forget to do so later, the incentive effect. This is one of the reasons why you cannot fund projects retrospectively, because in order for aid to be legal, it has to have an incentive effect. In other words, the aid has to change the behaviour of the organisation that is the recipient of the aid. So if you start a project and it's fully funded, and this used to happen under some old programmes just to get money out of the door, and then you got the funding later, your behaviour hasn't changed, has it? So therefore it is illegal aid under this provision called the incentive effect. So this is why retrospective projects are not permitted. You can, I think it says on here, if I remember rightly, you can have applied for the aid but not received the aid and started the project. That's okay, which is why when you receive that letter from the managing authority you can potentially start the project. Even though you haven't filled in the full application, it's treated as an application under the outline application process, so therefore it meets this incentive effect, because you won't have started the project until you've been told actually you're probably going to get this money. I don't know how useful this is, and I don't like this diagram because we've got a yes in the middle of here and all the no's. I've taken it mainly from the BIS or BAYS website as it is now. So are state aided resources involved? Just go through the questions I talked about. Is the beneficiary involved in economic activity? Does the beneficiary gain an advantage not normally available in the market? Is the advantage selective? Does the market economy principle apply? I haven't covered that yet, have I? That is, it's possible for a public sector organisation to behave as if it was a private sector organisation. In other words, to set up a equity investment fund, as an example, and invest in the same way that a private investor would act. Therefore, they are not providing aid, because what's called the market economy operator principle applies, or market economy investor principle if it's an investment fund. It's the same thing. And that's why we've got this horrible yes-no mix-up here. Are the service or goods theoretically tradable across member states? It's theoretically. No one has to prove they are actually tradable across member states. Only in theory they are tradable. And generally speaking, they usually are. So if you've gone down this list and turned up at this bit here, that means you're going to have to find a way of making, and you almost always will, by the way, unless there's no aid, you will have to go on to the next stage, which is looking at what applies. Is it within the de minimis threshold? Is it a service of general economic interest? So is it a public service required under some kind of statute or statutory provision? Then potentially it's not a state aid if that's the case. That would normally potentially apply to local authorities and other public organisations. I'm not going to cover that in any detail. Does it fit under the general block exemption regulation? We'll come on to that in a minute. Does the aid fall under an existing scheme? If none of these apply, then you've got a big problem, I'm afraid, because you're going to have to notify the proposal if you want to continue with it. I'll deal with that in the last slide. Generally speaking, you're going to find the answer in one of these if it's a structural fund project. Now, I want to mention at this point something that's really, really important to you guys, and that is that...
Sorry, could I just ask a question on the previous slide?
Yeah, of course, sorry, yeah.
So does it mean that GBA and de minimis are not notified schemes? Because there's this phrase of whether something's a notified scheme, and it comes up for when you look at R&D tax credits with HMRC. Yeah. And there's always this debate about whether GBA is a notified scheme and therefore the tax credit is only limited to the large scheme, or whether de minimis is not a notified scheme and therefore you can get the full R&D tax benefits for a small and medium company. So I don't know about tax law, but de minimis is a regulation. It's a form of exemption regulation. Right. It's a commission regulation because the commission have power under the treaty to define certain types of aid compatible with the internal market. So therefore they've issued a de minimis regulation that says aid that's below this level is compatible because it doesn't distort competition. You ask a very good question actually that somebody else asked as well, and that is that if you go onto the notified aid schemes on the .gov website, you'll find something that looks remarkably the same as GBA, as a notified aid scheme. Now, I don't actually know the reason for that, because I wouldn't have thought it was necessary to notify the GBA when the GBA itself is a regulation from the Commission. But for some reason or other, they have included GBA as a notified scheme under the UK notified scheme. So it's kind of, I guess it's like almost like a double protection of some sort. I'll have to get round to writing to them and asking them why they've done that at some point. It kind of doesn't matter because you can then use either route. But if you're putting in a structural fund project, generally speaking, you'll just quote the GBA regulation that applies, if indeed it does apply. You don't have to treat it as a notified scheme because it's covered by the regulation. It's just, I suppose, relevant when you're dealing with small companies, when you've got the option of going a GBA route or a de minimis route, because of the effect on tax credits, because it's significantly different. Right, okay. That's where... That's interesting. The advice is, we've been asked several times as to whether, we can't give advice obviously, but that's a question that's come up, whether GBA is notified and de minimis isn't, and the general consensus is de minimis isn't, as you said, it's a regulation, and therefore if you get a grant under that, you could get the full 130% tax credit. Okay. So if you apply the grant under de minimis, it's more beneficial, providing they're within the limits, to the recipient. Oh, interesting. I wasn't aware of that. That's so it's just an interesting point. Yeah, so there's an interaction with tax law as well there that's potentially, depending on complex. And obviously you can't claim the tax relief on the grant, but you take it away from the other bit. And, okay, thanks for that. I should say, by the way, there's often a number of different ways around the block. So you might find more than one GBA article might apply, or de minimis might apply, but you're using a GBA article. So you can often find different ways. And a lawyer will often give advice on state aid in a project and say, option 1 is this, option 2 is this, option 3 is this. If you ever get that sort of advice, by the way, do get the lawyer to commit to one option. Because if they just say there's 3 options here and leave it at that, which they like to do, DCLG will say, well, which one are you using? We don't understand from this advice. You need to be clear about which one you're using and why. Right, assisted area status. I need to press on in the next 15 minutes or so. This is really important to you guys in Cornwall because you have
assisted area status, which sadly means that you have less than 75% of EU average GDP here in Cornwall. The good news is that means that you get special treatment under state aid rules, and there is a specific regional aid, state aid exemption, and there are also, under a lot of the other GBA articles, there are also additional, or I should say, higher levels of intervention rate possible than in other parts of the country. So it's only West Wales and Cornwall, West Wales and the Valleys and Cornwall, that get this status. So whenever you're looking up state aid GBA, have a look at if there's any specific provisions for assisted areas, because in fact we looked at one after one of the previous seminars, and indeed there was a specific article that would be very helpful to that particular project. I'll skip over this slide because it's really just context. We did have something called State Aid Modernization in 2012, which builds on the State Aid Action Plan of 2008. And this is all stuff to try and simplify state aid and try and, we used to have, basically the problem was the Commission used to get swamped out with lots and lots of little projects, notifying, couldn't cope with all the work, took years to get anything done. So they tried to pass this responsibility on to member states through the block exemption regulation and encouraging, as I said earlier, 90% of aid to go through the block exemption regulations. So this is the reason why, as part of the state aid modernisation process. It also means that the block exemptions are supposed to help target aid on what is key EU policy. So EU 2020, smart, sustainable, inclusive growth. You'll find that the block exemptions try and pick up those themes and allow aid that is compatible with that larger EU economic strategy, growth strategy. But I won't go on too much about that. So this is what the block exemption regulation does. It covers an enormous list of things, which is, we'd be here for 2 days if I started going through them all, so I'm not going to do that. I have underlined a few here, which I will focus on. Regional aid. I'm going to mention environmental aid protection as well. Aid for research, development and innovation. Training aid. There's another page yet. And as you'll see here, a whole range of different aid for broadband, as I mentioned earlier, culture and heritage, sports and multifunctional recreational infrastructures, local infrastructure, which potentially isn't aid at all. If you put up, I don't know, a local swimming pool just for the residents of Truro, I'm not a big water park for tourists, then that's a local service really. It's not really going to be state aid. This is slightly out of date because they've just only recently approved some changes to the state aid regulation to cover ports and smaller regional airports, which will probably be useful for Newquay Airport, I would have thought. Outermost regions. Cornwall is not an outermost region, although it takes 5.5 hours on a train from London to get here, I discovered last couple of weeks. And notification thresholds have been changed for culture. Interestingly, I just mentioned this because I know it's important here, the Germans argued that tourism should be a block exemption, and the Commission rejected that. They didn't get a lot of support from other member states either, so it's not included in the changed regulation. Just in case you've seen something on tourism and wondered what happened, it's got chucked out, I'm afraid, in the consultation process. Now, regional aid is under what's called Article 14. When I'm quoting the articles here, they're from the General Block Exemption Regulation itself. There's a set of very detailed guidance here. I think it's 45 pages worth of guidance on regional aid, which I simply don't have time to go through here today, and you'll need to look at what's relevant to your project. But effectively, you're allowed aid for initial investment, so setting up a new establishment, extension of an existing establishment, starting up of an activity involving the production of products not previously produced, fundamental changes in the production process of an existing establishment, acquisition of assets belonging to an establishment which closed or would have closed had it not been purchased. So you'll see here a list of things. I've just summarised these, by the way, so you have to look at the regulation to see what you actually can do. Don't just take it from the slide. There are, of course, some rules relating to that. Investment has to be and the jobs created has to be maintained for 5 years or 3 years if it's an SME from the completion of the investment. At least 25% has to come from sources other than public subsidy. The company needs to provide written confirmation that they at group level have not made closures in the past 2 years and don't have proposals to do so. There are exclusions from the investment aid regulation in relation to transport, energy generation, firms in difficulty, and there are specific notification thresholds, which I'm not going to go through now,
apart from those that are on the screen there. So you'll see aid intensity 45% for small enterprises, 35% medium enterprises, 25% for large enterprises is the sort of general base rate. So this is at the level of the end beneficiary if you're providing aid under this particular process. I know I've skipped over that very quickly. I'll cover research, development and innovation aid. There's quite a lot here. I think I've already explained this, haven't I? The universities and research institutions are not generally treated as involving in activities that are economic in nature for their core educational and research activities. So, and that includes provision of infrastructure. So most university infrastructure is not state aid for that reason. There's also a thing called the 20% rule, you may or may not have heard of with universities and research institutions. If their activity, for example, within a building, less than 20% or less is not economic in nature, again, there are flexibilities with state aid, even if some of that activity is economic in nature. So quite important there. And where there's business collaborations and the organisation is paying the market rate, or there's ownership of the results, the intellectual property from that, again, there's a get out for state aid. Now, at the bottom here, there's something really useful, which I will come back to at the end, and that is a channel for state aid if not derived an undue advantage. So a lot of state aid, particularly in revenue projects, is what lawyers like to call wash-through. So the organisation is acting as a conduit for aid. So if you're running a business support project, the applicant is getting the aid to deliver the business support. So the money flows through the applicant. You may have some delivery partners, it's going to flow through them as well, and it's going to go through to the end beneficiary. So in all the stages, until you get to the end beneficiary, the aid is not retained for any other purpose than delivering the project. Therefore, it is the organisations are acting as a conduit for aid. The aid is washing through the organisations to the end beneficiary. So it's only at the level of the end beneficiary where you have to figure out, you know, where the aid intensity is and how it can be state aid compliant. It's a really useful argument used in so many different projects these days. Most of these activities I've listed here under RD&I are probably not going to be actually incorporated into ERDF projects because they are usually related to research activities anyway. But as you can see, there's a list of thresholds there. I generally would suggest that a lot of this kind of research-based stuff is either covered by Horizon 2020 or is actually activity that will be a precursor to ERDF projects. What we used to say in my region was that, you know, Horizon 2020, other research funds fund the research, ERDF funds the commercialisation, the next stage. How do we get this technology rolled out to businesses and into the market, creating economic growth and benefits? It's that commercialisation stage, so slightly different rules apply there. Investment for infrastructure for research and development, up to 50%, as you can see there. And this economic activity provision there, so division of infrastructure and the 20% rule might apply as well. Cannot exceed, it can be up to 100%, but support for the economic part cannot exceed 50%. So there's some rather complex and potentially contradictory rules that you need to consider there. Aid in respect of innovation, aid for process and organisational innovation under Article 29. So this is to do with clusters, investing in training and research facilities, open research laboratories. Seen a fair few projects doing that. Aid for process and organisational innovation, implementation of production or delivery methods, up to 50% of cost. Innovation aid, I think, is really useful for SMEs. I'm not going to run through each of those for time purposes. You can see them on the screen. One that's really useful is the bottom one, where actually you can have, it's almost like de minimis. It's not de minimis because it's under the block exemption regulation. So it therefore only applies to aid that is related to innovation support. So if the business has had de minimis support within the last 3 years, it doesn't count towards the 200,000 because it's under the block exemption regulation. People often say to me, well, what's the difference between that and de minimis? That is the difference. So it's not about, it helps in terms of cumulative funding sometimes. Now, environmental aid is my least favourite block exemption regulation. It's a horrible, horrible legal nightmare because you'll see on the top line here, I keep wanting to point at things and I can't. Restore a level playing field, so extra costs only. I did a project with an anaerobic digestion plant. Don't ask me to explain what they do, but they sort of soak up waste and produce energy out the other end somehow. It the costs that we could fund were only what were called the uplift costs between a normal installation and the super all singing, all dancing anaerobic digestion plant. And I think, how on earth do we establish what the uplift costs are between one and the other? We have to get an independent study to identify the costs, and then it's only those extra costs that are the eligible expenditure that you can treat under the environmental aid regulation. So as you can see, there is quite a process to go through to establish those costs and determine the level of aid. We did do it, and we did fund the project. It did work, but you know, it's a very complex process to arrive at the figures. Now I want to mention European Social Fund, training aid. First of all, generally speaking, aid to individuals is not state aid because an individual is not an undertaking. Before anyone corrects me, yes, I know they can be self-employed, so potentially they're an undertaking if they're self-employed, but generally speaking, I mean, for example, an unemployed individual receiving support from ESIF clearly cannot be a state aid because there's no undertaking involved in the process here. However, some ESF is used to support employers, isn't it, for a variety of reasons. So there may be occasions, not always, but some occasions where you need to consider the training aid exemption. So some ESF has to fit under the training aid exemption. A lot of ESF, frankly, isn't aid at all and doesn't normally cause any particular problems. Now, I know I've whizzed through those incredibly quickly and it's a very complex subject, but I want to just pick up on de minimis aid. Somebody at one of the previous seminars asked me to run through the stages of de minimis aid, which fortuitously is exactly what I was planning to do. First of all, de minimis aid, as I said earlier, is really aid that is below the level that is likely to distort competition between member states. So, and that figure has been determined by the Commission as €200,000 over a 3-year rolling period based on the fiscal year. What is the fiscal year? Fiscal year is the company accounting year, not the tax year. The company accounting year is the fiscal year of the organisation receiving the aid. Sometimes that causes confusion, so I thought I'd mention that. Of course, we're working in pounds and €200,000 is in euros, so we have to take the exchange rate calculated as the Commission exchange rate applicable at the written date of offer of the de minimis funding. So if you've got one that's close to the de minimis aid level, then that's how you determine if it's de minimis aid or not. Best to stay well clear of that. There are excluded sectors and there are specific de minimis regulations for agricultural and food products, which I am certainly not an expert on and don't plan to cover in this seminar. There are exclusions relating to aid for export related activities, which really means the distribution process of exporting. You can give aid to businesses to encourage exporting or aid them with exporting, planning, or visiting conferences and stuff like that. I think it gives an example here, trade fairs, but other types of actual aid to help a company distribute its products abroad can't be covered under de minimis aid anyway. Just worth mentioning the exemption there. Just very quickly, I just want to run through the 3 stages. You may or may not be aware of these. If you're going to run your project under de minimis aid, you're going to have to do 3 things. The last one has become slightly more complicated recently. The first thing you're going to do is ask the organisation if it has already received de minimis aid in the last 3 years. So they're going to then sign a statement to say if they've received any aid. If they've received no aid, that's good. If they've received aid, you need to know how much that aid is, because obviously over the 3-year rolling period you may potentially exceed the de minimis aid level. Once you've got that information and you've got a signed statement to prove you've got that information, you're going to estimate the value of aid that the project is going to provide to that organisation for fairly obvious reasons. You must make sure it doesn't exceed the de minimis aid level. And at the end of the process, you're then going to provide a statement to that organisation of the aid that's been provided. Now, this is where it's got slightly more complicated, because instead of just calculating the actual cost of the aid you've given them, which is what we've done over the previous programmes, you'll find that DCLG are now insisting on what's called a gross grant equivalent calculation, which is somehow assessing the market rate of the cost of the aid and then calculating that as the cost of the aid rather than the real cost of the aid. They're doing that because they had a visit from a state aid expert about a year ago who said, you're doing all this wrong, you've got to use this gross grant equivalent. So they're now rolling that out. When they come out to see you, if you're using de minimis, they'll come out to see you in an initial visit for the project. They will ask you how you've calculated your gross grant equivalent if we're using de minimis aid. Okay, I'm nearly finished.
time for a coffee break. Let's just have a quick look at capital projects. That's the final slide. Capital projects and state aid is much more complicated than we have time to go through. There's a big case called Leipzig-Halle, you may have heard about, 2 or 3 years ago now. And this kind of threw the state aid world up in the air somewhat, because it effectively said that transfer of resources to public organisations that operate within a commercial market shall be subject to state aid. So the construction of infrastructure with a view to subsequent commercial use shall be prima facie aid to the operator. Previously it's thought that effectively these types of public infrastructure were not aid because they were open to use from anybody. So in other words, like public infrastructure effectively. That is no longer the case. However, both of these projects would now no longer have to go through this route, because one was an airport, which is now covered by the block exemption regulation, just recently amended, a regional airport. The other one was a concert hall, which is potentially covered by the block exemption on cultural heritage infrastructure. So the Commission has sort of responded to this case by expanding the block exemption regulation. Nonetheless, if it's other types of infrastructure, potentially this case can apply, and it might be more difficult to get around state aid rules as a consequence. So any lawyer advising on state aid will be aware of those cases and will have an idea as to how they might possibly get around them. Notification is something you're not going to do, because you will find some other way to make your project compatible with state aid, I hope. If it's a really big project and it has to go through, you might consider notifying. I've only ever written one of these. A few years back now, I wrote a state aid notification to the Commission. It is a horribly painful process. What happens is that you spend ages writing your state aid notification. You have to go through the state aid unit at BAYS, it is now, isn't it? It used to be BIS. It has to come from the member state. You can't send it to the Commission yourself. So obviously you'll be working with the managing authority and they'll be working with the state aid unit. In fact, you have to send it through a computer system that they have to give you access to. But setting that aside, what happens is that you send it in and you wait 3 months, because that's the time limit. They may have changed the time limits under the new regulation, but normally you wait 3 months. You'll hear absolutely nothing other than you'll get an acknowledgement that they've received it. After 3 months, on the very last day, you will get a stack of questions. Absolute stay with 1 month. You've got 1 month to answer the questions. You'll get a stack of questions, 1 month. So you'll run around like a headless chicken and answer these questions. A lot of the questions will be simply asking you for more detail on what you've already said. It's a bit of a stalling tactic by the Commission, because nobody's gotten around to looking at the project properly. So a stalling tactic. You'll then send it in. You'll then wait another 3 months and hear absolutely nothing for 3 months. And then if you're very lucky, you will get a state aid decision. If it's slightly more complicated, you'll get another set of questions. So you see where I'm coming from here. This process can go on forever. Every time the Commission sends you questions, it stalls the process. And the process timetable starts again. So it can take years. There have been state aid cases in the system for years and years and years, potentially, through this process. So you don't want to do it. It's a lot of work. If you do go through this process, and interestingly, this is the best legal certainty you can get, you eventually get a decision signed by the Commissioner, recorded in the official journal, that the project is state aid compatible. It will give reasons, obviously. And you can then go ahead. And of course, you've got a bit of paper. And this is the problem that you'll have with all other projects that don't go through this process, is that you don't have legal certainty, because only the Commission can give a decision on state aid. No other organisation in the UK. Anyone else is giving an opinion, aren't they? If you ask me for a state aid opinion, I'll give you an opinion. If you ask a lawyer, they'll give you an opinion, put it on a bit of headed notepaper. It's an opinion. You can't ask anybody for a state aid decision, only the Commission through the notification process. And even the Commission's decision could potentially be challenged in the Court of Justice of the EU. Only happens obviously in really controversial, difficult cases, but potentially it could happen. So even that could be overruled. But you've got a greater level of legal certainty if you have a decision. But you won't want to do this. Seriously, you really won't want to do it, because the problem is it's going to delay your project for so long, you'll end up simply not being able to do it. It's just not a viable option. Right, just finally, I know I'm way over time here, sorry about that, but just in practical terms, when you are filling in the form, full application form, there's a state aid section, section 10 I think it is. You will need to carry out an assessment at all levels of the project, as I described earlier. So the beneficiary of the funds. Beneficiary of the funds is, in legal terms, the applicant for the funding.
At that level, is there any state aid? Go through the test, look for the block exemption. Delivery partners, the same thing. Go through that stage. Potentially delivery providers or contractors. Generally speaking, if you've contracted a service out, it's highly unlikely to be state aid because there will be a a competitive market decision to deliver those services. Not going to be a state aid. I read a very interesting academic paper a few months ago which questioned why that was the case, but nonetheless that is how it works. So what usually happens is that you'll work through to the end beneficiaries. Notice I've got this different terminology here: beneficiary, the recipient of the funds, the project applicant, the end beneficiary, the organisations who will actually receive the benefit of the project. So the end beneficiary level is probably where you're going to have the most difficulty in meeting state aid requirements. But you have to, DCLG or even DWP will want to see you've assessed state aid at each level of the project in section 10 of the application. Get your lawyer to do the same thing and get some headed note paper to make sure that it's covered. I've covered the wash through already, and you do have to have independent legal advice on every project. It's now a requirement. Right, at that point I think we're absolutely desperate for a coffee break, but has anybody got any questions before we move off state aid?
Andy, sorry, just a very quick one on de minimis. When you said about the current fiscal year and 2 previous fiscal years, that's taken from the end beneficiary. You said that they're not the tax year.
Well, assuming you're applying de minimis at the level of the end beneficiary, then it refers to the accounting year, doesn't it, in the regulation? Yeah. There's often been confusion about what's accounting year mean. It actually means I think it actually says fiscal year, to correct myself. Yeah. Fiscal year means the accounting year of the organisation. So, I mean, my company, for example, has an accounting year that ends in August. It just happens to be when I set the company up, and it runs for a 12-month period. So it can be under. It depends on different member states. There may be different tax arrangements. It doesn't mean the tax year. It doesn't mean the calendar year, which on EU funding is based. It means the fiscal year, accounting year of the recipient organisation. To clarify. Okay.